Understanding Living Trusts, a comprehensive guide. A living trust is a powerful estate planning tool that serves to protect an individual's assets and dictate their distribution after death. This legal arrangement simplifies the process for beneficiaries and can often help avoid the complexities associated with probate, a process that can be lengthy and costly. In this article, we will delve deeper into what living trusts are, how they work, their types, advantages, disadvantages, and how they compare with wills. What is a living trust? A living trust, also known as an inter vivos trust, is established by an individual known as the grantor, or settlor, during their lifetime. This trust allows the grantor to transfer their assets into a trust for management and distribution purposes, with clearly defined terms laid out in a legal document. At the heart of this arrangement is a trustee, who may either be the grantor, a trusted individual, or an entity responsible for overseeing the trust's assets. Key features of a living trust. Assets protection. Living trusts help protect assets from potential creditors and legal challenges. Probate avoidance. Transfers of assets made through a living trust do not go through the probate process, saving time and expenses for the beneficiaries. Privacy. Unlike wills, which become public during probate, living trusts keep your estate information private. How living trusts work. Living trusts operate by designating a trustee to manage the assets held in trust and distribute them after the grantor's death. The process begins with creating a trust document that outlines the rules governing the trust and the assets to be included. Once established, the grantor transfers the title of their assets to the trust, which could include real estate, financial accounts, bank accounts, stocks, bonds, personal property, jewelry, antiques, art, business interests. Mechanisms of a living trust. 1. Establishment. The grantor defines the trust's terms and appoints a trustee. 2. Funding. The grantor changes the title of assets to reflect ownership by the trust. 3. Management. A trustee manages the trust during the grantor's lifetime and passes on the assets according to the grantor's stipulations after death. Types of living trusts. There are two primary forms of living trusts, revocable and irrevocable, each offering different features and benefits. 1. Revocable living trust. A revocable living trust allows the grantor to maintain control over the assets and make changes to the trust as needed. Key aspects include the ability to amend or revoke the trust at any time. The grantor commonly acts as the trustee, managing the assets directly. Upon the grantor's death, the trust typically becomes irrevocable, solidifying the asset distribution as initially outlined. 2. Irrevocable living trust. Unlike revocable trusts, irrevocable trusts prohibit the grantor from modifying or revoking the trust once established. Advantages include protection from creditors and lawsuits. Potential tax benefits, as the assets are removed from the grantor's estate, which may reduce estate taxes. Restrictions on the grantor's control, thus ensuring that the assets are strictly managed in compliance with the designated terms. Living trusts versus wills. While both living trusts and wills are essential elements of estate planning, they function differently. Living trust takes effect immediately upon creation. Bypasses probate entirely upon the grantor's death. Maintains privacy, as trust details remain confidential. Will takes effect only upon death. Requires probate to distribute assets, which can be public and time-consuming. Allows designations for guardianship of minor children and appoints an executor. Advantages of living trusts. Efficiency and flexibility. Avoids probate, allowing for quick asset distribution. Offers privacy regarding the estate's expenses and distribution. Control and management. Allows the grantor to manage assets during their life and handle disbursements in case of incapacitation through a designated successor trustee. Protection from creditors. Specific structures, especially with irrevocable trusts, provide a level of asset protection. Disadvantages of living trusts. Complexity and cost. Setting up a living trust often requires legal assistance, incurring additional costs. Revocable trusts do not provide asset protection from taxes or creditors while the grantor is alive. Transfer of title. The necessity of retitling assets to the trust can involve additional steps and could incur filing fees. Steps to create a living trust. Creating a living trust generally involves 1. Choosing the type of trust, decide between a revocable or irrevocable trust. 2. Designating beneficiaries and trustee, clearly define who will inherit assets and who will manage the trust. 3. Drafting the trust document, consult an estate attorney to ensure compliance with laws and regulations. 4. Fund the trust, transfer ownership of selected assets to the trust. 5. Safeguarding the trust document, store the original trust document in a secure location, such as a safe deposit box. Conclusion. A living trust can be a vital element of solid estate planning, enabling individuals to manage their assets efficiently and ensure they are appropriately distributed after death. By understanding the distinctions between living trusts and wills and weighing their advantages and disadvantages, individuals can make informed decisions that serve their interests and the best interests of their beneficiaries. For anyone considering establishing a living trust, consulting an estate attorney can provide invaluable guidance to ensure that all aspects of the trust are created correctly and in accordance with your wishes.